Buyer is LTKM Berhad, listed company lah. The seller, shareholders of target company. Target company is local assembly Sdn Berhad. Target company is a private company to be injected into a listed company. Chase price 336 million. A mix of cash and shares. Way of payment, allotment of shares equal to 336 million. Major disposal. Okay, precondition. Major disposal of all assets and liabilities. Special dividend, capital repayment, share consolidation, injection. What does it mean here? The listed company is now involved in poultry business. Poultry business, right? Yeah, they wanted to inject a fresh business into the company, but then the existing business will be taken out from the listed company. That was the plan. Type of deed, cash and share deal. Other condition, waiver to undertake mandatory general offer. LTKM will be changed. Will be changing its name to LA Technologies Sdn Berhad to represent the new business. The new business. The existing business is the existing asset 450 acres of poultry farm in Malacca. Okay. So how is it done? LTKM Berhad, asset liabilities employees, debt borrowing trade creditors, LTKM Berhad will acquire, SPA will acquire local assembly Sdn Berhad from the shareholders. LTKM will allot shares. Then the existing business will be sold back to the controlling shareholder. So ultimately, LTKM Berhad will be owned by the present shareholders of local assembly Sdn Berhad. Local assembly will be injected into LTKM Berhad, so that will be the new business. Microchip business ke? Yeah. What happened to this transaction? RTO entails a profit guarantee for 2 years. Okay, let's go through the write-up quickly lah. Okay, LTKM, the company has cash and bank balance of 55 million, while this is total borrowing stood at LTKM slipped into the red financial, the company with financial performance. Some market observers believe RTO reverse takeover entails a profit guarantee for 2 years. What does it mean here? The vendors will give a guarantee. The vendors will give a guarantee to the LTKM. LTKM will be the subject RTO with local assembly, which commenced business in 2000. Local assembly was co-founded by Chai Boon San Group. Collectively, they own 70% of the stake in the company, providing a profit guarantee of 28 million. So there is a profit guarantee accorded to LTKM by the promoters. It's worth noting that Tan Sri can local assembly deliver profit guarantee? Analyst covers the 336 million RTO deals essentially values local assembly at historical price. Okay, this is the valuation. The 336 million RTO deal essentially values local assembly at historical price earning ratio of 16.8 times based on an audited net profit of 20 million. 20 million multiplied by 16.8 gives the value of 336 lah. So quite high, for comparison, VS Industry and SKP Resources are currently trading at price earning ratio at 19 times and 14 point. These are comparable. Okay, that's valuation at 336 million. The forward PER of local assembly is 12 times based on PAT of 28 million. Okay, special dividend. LTKM price climb, the announcement, blah, blah. Under the proposal, LTKM will sell its existing chicken egg production business and other assets for 150 million. The proceeds will be distributed to the existing shareholders of the company by way of special dividend. Maknanya, the business LTKM will be sold off. The proceeds received will be paid by way of special dividend. The proceeds will be distributed to the existing shareholders of the company by way of special dividend and capital repayment. Capital repayment. Yesterday we were discussing about Mas, Uda, those were the example of capital repayment. Theoretically, the current price of 1 for 1 ATM share will be adjusted to 30% apiece. Subsequently, the company will undertake a 2.1 share consideration, which means the share price will further adjust to 60%. Yeah. Anyway, so I think, yeah. You can check. I think the transaction was not completed. It was aborted eventually. The next is basically a reverse takeover of Quill Capital Trust, QCT by MRCB Central Berhad. MRCB Central. Now, earlier I mentioned that the buying party must have share capital, right? But this is not the share capital. They issue units. This is a real estate investment trust. Reverse takeover of Quill Capital Trust by MRCB Central. There is a, I think, Q Central. Q Central building was owned by MRCB 100%. MRCB injected this building into Quill Capital Trust, yeah, and they were paid by way of units in Quill Capital Trust. So by selling the building to Quill Capital Trust, in a way MRCB monetized the value of that Q Central. But it was not all paid by cash. They were partly paid by units of the Quill Capital Trust. So in a way, through the process, MRCB became the single largest unit holder of Quill Capital Trust. Yeah. I was seated next to the shoulder of MRCB at one wedding reception. I was talking to him about this subject lah. Dia kata the company did not have cash. The company did not have cash. When we sold this with cash, we brought in 700 million cash into the company. Yeah. We brought in some cash, and we got some units. Yeah. So in a way, the company is much more liquid because we have cash. Otherwise, the asset ownership that doesn't allow us to have cash. Yeah. So what are the transactions here? I think there are 5 transactions here. 5 transactions. Proposed acquisition by Maybank Trustee, Maybank Trustee Berhad, solely in capacity as trustee for on behalf of the QCT of the property, of the HQ of the property lah, for the purchase consideration of 750 million. Proposed placement between 55 million units to 85 million units of QCT by way of book building. At a price to be determined later to partly finance the proposed acquisition. The QC, Quill Capital Trust will be issuing units through book bidding exercise to raise capital at a price determined later in order to partly finance the acquisition. Proposed authority to allot and issue up to 3% total units in circulation. Proposed increase of the existing approved fund size. But the fund size was, I suppose, smaller. Now you got to issue new units in order to pay for the acquisition. Proposed change of name from QCT to MRCB Quill REIT. MRCB as the owner as the seller would require in terms of visibility the Q Capital Trust, Quill Capital Trust to be renamed as MRCB Quill REIT. Quill REIT. That's a transaction. Let me see. Okay, kejap. The trustee entered into conditional sale and purchase agreement with MRCB Central Sedang Berhad for the proposed acquisition on 10 April 2014. Submission of valuation report, consideration of the SPA, cash consideration, issuance of new units. SC via a letter 14 October approved the increase of the fund size, the proposed placement, proposed authority together with listing and valuation of the new units will also be listed on the stock market. So you need to get Bursa's approval lah, for the admission of the new units, for the listing and quotation, for the listing, for the admission and for the admission and for the listing of the new units on the stock market. Bursa Securities approved for the listing quotation. Okay. 23rd March, CPs were fulfilled. 30th March, considering units have been listed and quoted on the Bursa Saham lah, Bursa Securities, as well as 65,000 units for the proposed placement. Proposed 31st March proposed change of shareholding structure in QCM had also been completed. Via the property unit swap, MRCB obtained the ownership of 31%, but below 33% of QCT, and the name of QCT was changed to MRCB Quill Rate on 27 May 2015. So that was the structure of the injection here. MSP, MRCB sort of sold the property to Quill Rate. Quill Rate acquired the property, payment made by two ways: 486 million in cash, 264 million certified by way of issuance of the units. So ultimately, MRCB controlled 31.18% of MRCB Quill Rate, and MRCB Quill Rate owns 100% of property. Kan, macam Pelaburan Hartanah Bumiputera is also a REIT company but non-listed. Whereas Quill REIT here is a listed company. Basically, REIT is a company that acquires commercial properties for yield, for yield, for rental income. I mean, a property is not REITable unless it gives a yield of at least 5.5%, 6%, amongst others. Yeah. I mean, amongst others, basically. So I think this, Q Central is a good property, I suppose, because of location. You know. So what else? Page 3, yeah. I mean, who are the parties? MSP, MRCB as a vendor, QCT acting through trustee as a purchaser. The total purchase price 750 million. There was one adjustment. The purchase price was reduced. Originally, the agreed price was 750 million, but it was reduced to 740 million. Upon inspection by independent valuer, I mean, of the value of through there was adjustment made to the purchase price after the QCT, I suppose, obtained the services of a property valuer. Adjustment represented approximately 1.33% of the initial market value of the property. Therefore, the payment structure was adjusted. Okay, page 3. Okay, these are the details of the property. Page 4, I think. Page 5. Okay, page 5 to what? CPs. What are the CPs? Approval being obtained from the shareholders or MSP? MRCB lah. MRCB needed to obtain shareholders approval. So if you are interested to understand this deal, you go through Bursa punya Bursa punya website, go to the MRCB, stock, you can download the circular to shareholders. You can get a lot of information inside there. Then you can dissect this thing lah, basically. Approval being obtained from the unit holders of QCT. These are the more or less shareholders lah. Whereas, the unit holders of QCT must approve the proposed acquisition, because the issuance of new units will result in dilution of their, unit holding, basically. Approval being obtained from the Securities Commission for the valuation of the property, proposed placement of the units, issuance of new units pursuant to the proposed acquisition, proposed placement, proposed authority, listing of and quotation of the new units on the main market of the Bursa Malaysia Securities Berhad, and proposed increase in fund size. These are all, would require SC's approval. Approval being obtained from Bursa Securities. What else? Valuation exercise, next one. Okay, now, the last bullet point, where applicable or required, MSP or other person acting in concert with it having obtained approval in relation to the exemption from SC from the obligation to undertake a mandatory offer for all the remaining units not already owned by MSP. Where applicable lah. In the event that the units issued to MRCB plus parties who are friendly plus parties who are acting in concert exceeds 33%, they will have to undertake mandatory general offer lah. But here they have purposely structured it so that the shareholding level, the unit holding of MRCB is below the threshold of 33%. Okay. Next one, approvals. Okay. I think that's it. Okay, any question on the RTO? Let's move to the next topic. Okay, what's the next topic? Shareholders agreement. What is shareholders agreement? What is a shareholders agreement? An agreement to regulate the relationship between parties as shareholders of a company. Normally, it's needed, especially when you are a minority shareholder. If you are a minority shareholder, you need shareholders agreement more than when you are a majority shareholder. But if you are a majority shareholder, you still need shareholders approval and shareholders agreement to tie the other party to bind the other party from behaving unreasonably. Sometimes the minority shareholder can ruin your business by not cooperating. You may encounter a situation in which a minority shareholder owning say 25% or 20% of the shares refuse to attend general meeting. Biasa. Now what do you have to do? You can go to court. You can go to court and seek a declaration to say that you can proceed to convene general meeting without the presence of the dissenting shareholder lah. Contoh. Sometimes it's important that, say for example, your group, your company, you want to enter into joint venture. Basically, your group and the other party. The other party owns, say, 49%. You own 51%. Sometimes it's important for you to structure your shareholding by having two companies. You split your shareholding instead of one company owning 51%, you split it to two entities, maybe 49% and 2%. Because quorum for general meeting ni apa dia? Dua ke? Selalunya dua kan? Is it possible to have one? Is it possible to have one shareholder? I mean, unless you can reflect in the constitution. I suppose you can reflect anything in the constitution as long as it's not contrary to the Companies Act 2016. Where there's a basic regulation specified in the Companies Act, you cannot alter lah. But I suppose, I'm not too sure whether you can specify a resolution, quorum to be one director. Boleh ke? Sorry? In the constitution?
Cakap sendiri.
Cakap sendiri. Okay, so now contracting out the law ni, is it possible ke? I mean, can we contract out of the basic protection of the law? I mean, the law will generally strike out any attempt to do something to get out the requirement of the law lah. But I suppose, look, I mean, between two consenting parties, Malaysia also upholds the concept of sanctity of contract, right? As long as parties are competent to contract with each other. So I think my practice is that I would still do something to contract out of the law by specifying that each parties have negotiated this freely, blah blah. They are aware of the legal consequences, and they agree, for example, among themselves that one person constitute a good quorum for general meeting. Contoh, to avoid any circumstances in which one party delinquently misbehaving lah, So now, if your position, if you are a shareholder but you do not have enough shares to procure the passing of special resolution, then you should consider to have shareholders agreement. Now, shareholders agreement ni pun, when there is a conflict in relationship between the parties, you need to address the mechanism to dispute lah. Sometimes the dispute resolution may entail in one party buy out the other party. Selalunya in a joint venture agreement or shareholders agreement, the relationships are cordial. In not many instances in which, in most circumstances, the relationship is cordial. But there are instances in which the relationship is not good enough that culminates in one party leaving the company. When I was in Petronas, I remember negotiating SMDS shareholders agreement. Petronas stake in that company was only 10%. SMDS now may be profitable. I do not know what advice I gave to Petronas at that juncture relative to my knowledge. I mean, but I suppose the stake of Petronas in there is still there. Meaning that I think I think still 10%, but I think the relationship, although 10%, maybe there was no operation. The concept of running a company is very simple. The majority is to rule, the minority is not to be oppressed. It does not mean that the minority must prevent the majority to manage the company. As long as the management of the company is done by the majority shareholders in a good fashion, there is no basis of complaint. I mean, it is incorrect for minority shareholder to exercise excessive power to the extent that it blocks or it slows down the process of decision making of the company, basically. So you need to strike a balance lah. And to be honest, the legal concept, the common law concept of operation in Malaysia ni pun quite established. If you are an investor, kata you are a minority investor, you got oppressed by the majority shareholder. There are enough remedies for you to sort of seek protection. Seek your remedy lah. Not using the shareholders agreement, but using the common law or decided concept lah. There are many legal remedies, common law remedies. You talk to good lawyers, I'm not a litigator, they will find various remedies available. I was advising one interesting case, real case. Now the Malaysian party is the producer of local product. The product was not highly in demand 20 years ago. So they entered into a transaction with two foreign parties. The two foreign parties and the local party created a JV company. The JV company will be entering into long-term contract with the Malaysian party to buy the product at a very discounted price, at a very competitive price. Over the years, the JV company was doing a lot of profit. The JV company was doing a lot of profit because the demand for the product went up. The Malaysian party was not too happy with that. The Malaysian party owned 60%. The two foreign parties owned 20% each. Okay? So there were a lot of cash built up with the company. Yeah. The company was profitable because they secured a very long-term supply of the product. The price was heavily in favor of discounted, heavily in favor of the JV company. But the foreign parties, which were the technical partners of that product, the local party was not able to sell that product. The cash surplus was not able to be paid out as dividend because it was blocked by the majority shareholder. So there were no, capex. There were no future capex expenses, further capex expenses to be invested by the company, and yet any request for dividend payout was vetoed by the 6% shareholder. So finally, the 6% shareholder came to us. They came to us, minta opinion. Azmi, could you please look into this and advise us whether our conduct in the past, over the last couple of years, of not allowing dividends to be paid would amount to oppression? They needed to check with us. So we look into the document drafted by US law firm, because the two parties were from US. We discovered that there was a statement in the recital of the shareholders agreement. In the recital in the preamble. Recital ke preamble? Sama. Recital ke preamble? Sama. Okay, the objective of the joint venture amongst others to maximize profit and maximize the payment of dividend to the shareholders. Then you look at the dividend clause. Dalam shareholders agreement ni, there is also dividend clause. Now, dividend clause ni, sometimes dividend clauses are drafted generally. The parties shall agree to adopt a dividend policy as good as as progressive as possible, taking into account the further capital expenditure of the company, blah blah blah. You know, that kind of dividend policy statement is not useful if you are a minority shareholder. So coming back to this particular transaction, dia kata profit after tax of the company after the finalization of the audited accounts, at least 50% must be paid as dividend. Yeah. Yesterday I mentioned about PNB's policy, right? PNB's policy of dividend is that 75% of the PAT must be declared by dividend in all the invested companies. At least that is the expectation of PNB companies. I'm going to ask a couple of people. I'm going to ask Khazanah ni. Is there a tenaga? Is there a Khazanah approved policy tak of dividend for TNB? Ada? Not sure.
Not sure.
Yeah, you can ask them. You can ask the COSAC. Is there dividend policy of Khazanah that was imposed or conveyed to TNB? It's a very big issue. It's about this discussion is a very big. Anyway, let's come back to the story. So the shareholders' agreement clearly stated that 50% of the profit after tax must be paid dividend. And you realize that the last 2-3 years, any discussion of payment of dividend was suppressed, were opposed by the local party. So we said to them, I think your conduct, if the case were to go to court, most likely you will lose the case lah. So we shared the opinion to the Malaysian party. So what happened? They took the opinion. They were not interested in paying dividend. They bought back. They negotiated to buy back the 40% shareholding from the foreign party. So sometimes, moral of the story is that, what are the products in Sabah now? Contoh, what are the products in Sabah now which are not, which Sabah is producing in massive volume, tapi tak ada demand. You may be selling cheap, but you don't know the demand of this product. It may change. Sometimes you need to have balancing clause lah. You need to have adjustment clause. You need to have, maybe you agree on the price, but the price is subject to variation. Contoh, amongst others. Anyway, so now who are the parties to the shareholders agreement? The shareholders lah. Tapi it's not complete unless the company is included. Tadi we were looking at one document. What was that? And they included the parties. There was one transaction that we were discussing.
Subscription, or was it?
There was one. Was it yesterday? Case apa?
Is it shareholder? The one that the Singapore drafted.
That's correct. The option too. The option. Yeah, they specify. Okay, so I think the company should be included now. Now, when you negotiate shareholders agreement, you must always be mindful of the future events that will take place. You may not realize what will happen. Now, I cannot imagine that Petronas still remain as a shareholder for share media synthesis, which I negotiated 34 years ago. I hope he has granted some adequate safeguard to Petronas, but Petronas is still there. Now, I'm going to say about one matter, one case. There was one small company, one small businessman, small-time businessman in Sarawak. He was able to secure one piece of land, then enter into shareholders agreement to commence plantation business with one small listed company. That small listed company, one listed company, the core business of that listed company adalah adalah property development, but they invested in a plantation. Which is basically, not the core business lah. Plantation company having a JV with a Sarawak businessman in a plantation business. There's another listed company owned by the same holding company, which owns plantation business, the core business plantation, but they have property development company. Anyway, to cut short the story, now the Sarawak party, because of the weaker bargaining position, accepted the terms and condition in favor of the listed company lah. Eventually, between the two of them, between two listed companies owned by the same holding company, they did a rationalization. The plantation business ni was transferred to the plantation company. To the plantation company, to the listed company, to the other listed company whose core business is plantation. Yeah. So then, the Sarawak party is now negotiating, is now having a JV with a much bigger plantation company. I suppose his bargaining position is even weaker, but they have signed a document already that gives so much of power to the majority shareholder or to the listed company. But now that stake by the listed company is swapped by another listed with another listed company. Okay, we follow. Now the listed company tadi did another merger. That merger tu ended up with Sandabi. You faham tak? So the Sarawak party is now in joint venture with the Sandabi. One listed company move to another listed company. The share will transfer lah. Move to another listed company. Finally merge with Sandabi. So the Sarawak party remains in JV with Sandabi Berhad. Dah plantation kan. Lagi kecil kan. So what does it mean? Okay, tak apalah. I own 40% ke. Now I am in joint venture arrangement with Sandabi Berhad. Eventually, that stake was purchased by a big Japanese company. The Sarawak interest too was purchased by a big Japanese conglomerate, 10 times bigger than Sandabi. 10 times bigger, besar lah. It's a big, I wouldn't want to mention name lah. So, when you buy shares in a JV company, you will have to abide by the terms, as in terms, right? That's normal, through deal adherence lah, So would the Japanese party be agreeable to assume the position negotiated by the small Sarawak businessman 20 years ago? They kata, no. We are not interested. We want to enter into a fresh shareholders agreement. We want to enter into a fresh shareholders agreement. And what was the response from Sandabi? Suddenly the Japanese party, I've signed this document with, Datuk from Sarawak, contoh. The agreement was entered into 1988. 2017, the Japanese party want to buy out the stake of that Datuk in the JV company. So they approached. So I'm happy to buy out the Datuk stake in the JV company. I would be in essence partnering with Sandabi lah, but I wouldn't want to be bound by the terms that such Datuk negotiated with the first listed company in 1988. I want to negotiate a new shareholders agreement. So what was the answer? Should Sandabi accede to that request? Or no? Siapa said no? Sandabi setuju. I think it's okay. Why? Because we want to be seen in partnership with that global name. The Japanese party was investing in that company in order to understand the biodiversity. Partly from the production, not because of revenue, but they wanted to understand, they wanted to have a partnership with a big plantation group to understand the diversity issues and ecosystem issues, and for research, for technological, amongst others. In what ways basically the CPO ni, palm oil production can be used for scientific, food production, that kind of stuff lah, basically. So I think Sandabi agreed to that. Okay, fair enough. Because this is a global name, it's a big name, we are happy to accommodate them. Let's negotiate a new, transaction. So I think that's one equation. Another case. Now, one group, a Malaysian party, listed company, enter into an arrangement for oleochemical production with a German group. The German group is bigger size-wise. So the Malaysian party was a company that generates something like 400 million profit, gross profit. But not considered to be big enough lah. You look at even Sandabi now, profit could be what? Maybe 2 billion, 2.5 billion, Sandabi plantation lah. So that entity also merged with Sandabi. The German group, okay. The German group in that instance was granted management power over the business affairs with no statements about the time frame. for that management power to be accessible, as if the management right granted to the German party tu would be continuing. I mean, so that was a mistake lah. Kan? The German party subsequently sold the stake to another party. I mean, another company from Asia. Kan? So I think there was, effectively, sometimes you may be negotiating a position from the position of weakness lah. You may not be in the best position currently, but it does not mean that that state of the situation continues forever. Kan? I mean, contoh lah. So I think you must always address the possibility of you being merged with another entity, and perhaps the position that you negotiate in the shareholders agreement to need to cater for any possible upside or possible change in which your bargaining position changes. Yeah. Years ago, when I was on the board of Sandabi, Sandabi had a joint venture with Setia. Yeah. Sandabi, SP Setia, and EPF to acquire Better Sea project. Better Sea project ini prestigious, but I think the return is not too good lah. Not my statement. You can read the newspaper. So anyway, both Sanabi and SP Setia were owned by PNB. At that juncture, yeah, that's correct. It was partly owned by PNB, but PNB did not have control of SP Setia yet. So I think the rivalry between the two of them, they decided the chairmanship of JV company must be alternated between nominee of Sanabi and nominee of SP Setia. I think the first chairman shall be Tan Sri Liu. For example, he was the managing director of SP Setia at the juncture lah. That was before he started his company Eco World lah, basically. Then you alternate. Even now, that alternation continues even until now. So the moral of the story is that think of various scenarios that may take place in future. I mean, amongst others. Okay. Company must be included as a party to complete the equation. Okay, now item 3. Yeah. A company is bound by the Constitution. Okay. The Companies Act. Constitution, the Companies Act. Shareholders agreement is an agreement between the shareholders. Now, Malaysian practice is that people do not typically modify the constitutions to reflect the terms of the shareholders agreement. I mean, sometimes client, they want to save money. Tak payah. After there is a clause in the shareholders agreement, if there's a conflict, shareholders agreement will prevail. Yeah. But I think if you negotiate with the UK companies, generally they want US company, UK company, they want the provisions to be reflected in the constitution. Yeah, I think I would say it's a good practice. It's painful, plus to many lawyers, it's not an intrinsic assignment. Trying to modify the constitution, trying to amend the constitution to be consistent with the shareholders agreement is a tedious and not prestigious assignment. You want to be doing M&A work, kan? You want to do RTO work. What work you're doing? I'm amending the constitution to comply, to reflect the terms of the shareholders agreement. Anyway, so people tend to put aside, we don't attend this. There was also another case I want to share. One company had a JV with Japanese party, a big Japanese technology group lah, basically. It was 70-30 lah. I mean, the Malaysian party. In 1981, the shareholding of that Malaysian party was transferred from one government company to another entity. I mean, not quite owned by the government, but related to the government. Yeah. So there was a change of party A or company A who signed the shareholders agreement. Now the shares were transferred to party B. Okay. So what happened? You need to, technically speaking, you should amend the shareholders agreement lah, to capture. So let me see. I think originally, yeah, you so. And then the party B subsequently split the shareholding. Kan, by some shares were held by them, some shares were held by, funds that party B created. Yeah. Contoh. Now again, that documentation, the JV company was dependent on the Japanese party for quite some time. Yeah. But over the years, the local party plus the Malaysian, the party B, had expanded their operations. They have got other activities using the other companies in the field of technology, telco technology amongst others. But the provision remained entrenched, drafted slightly in favor of the Japanese party. You follow? Jadi, I mean, much later, what year was that? 2017 to 2018. I mean, I raised the subject. The document that you have now was representing the state of situation in 1981, 1993, for example. So many years have lapsed since those, but documents were capturing the documents captured the state of the situation prevailing at that time. Did not quite reflect the position now. So I think it is also a good practice to always, every time there is a change of shareholding, change of position, or if there's something, if for example, local party that was supposed to be a more silent partner suddenly turns out to become more, is doing more, for example, related to the company's operation, you need to capture all this process so that the agreement is contemporary to the situations really happening between the shareholders vis-a-vis the company. Yeah. But how many people would want, I mean, how many companies would do this? I mean, you have got the shareholders agreement that could be signed, for example, 20 years ago. Kan? If you were to review the shareholders agreement, it may no longer reflect what's being done now between the parties. Kan? Contoh. You know? Now, the first point, the fourth point, the fourth item, what are the distinctions between shareholders agreement and joint venture agreement? Kenapa some documents we call it shareholders agreement, in some instances we call it joint venture? What's the difference between the two? Yeah. Shareholders agreement is an agreement governing the relationship between two or more parties really as shareholders. Dia tanya soalan, waktu dia jawab. Okay. When the relationship between the shareholders goes beyond just relationship as shareholders, involves a pursuit of greater undertaking, typically they will call that agreement as joint venture agreement. Yeah. When the agreement covers other activities rather than just as shareholders, contoh, we are going to buy land, we are going to build plant, we are going to invest in technology, we are going to enter into licensing document. Okay. The main document there, you call it joint venture agreement lah. Okay, I mean, when I started my AAA, I was doing a lot of work for Proton. Kan, Proton was tolong itu sekejap, iris whiteboard sekejap. Proton originally was a joint venture company between three parties. Kan, Proton, I mean Highcom Holding Berhad, Mitsubishi Motors Corporation, and Mitsubishi Corporation. Kan, they established a joint venture company known as Proton. Yeah. Okay, let me just erase. Let me just draw. So, boleh. This was the Proton joint venture lah. I mean, yeah. Mitsubishi Motors Corporation, Mitsubishi Corporation, and Highcom Berhad, culminating in the establishment of Proton. Perusahaan Automobil Nasional Berhad. Yeah, Proton. So, between them, JV agreement, joint venture agreement, not shareholders agreement. There was a licensing. Yeah. There was a JV agreement. Number 2, licensing agreement. Licensing agreement, i.e. for the grant of the license for Proton to produce, basically Mitsubishi model car to be rebadged as Proton, to be known as Proton, the technology licensing. And number 3, there's a technical assistance agreement. Technical assistance agreement also provided by Mitsubishi Motor Corporation in order to assist Proton in the production stage, of the car. Yang keempat, there was a site or land purchase agreement. Highcom owns a company by the name of Highcom Indungan in section 19 lah. Highcom Indungan. They developed the land around section 19 of Shah Alam. One of the site was sold to Proton. SPA of site lah. Proton needed to obtain license from MITI, right? MITI. License, manufacturing license lah. Manufacturing license. One more thing. Proton will be building on the land the plant lah, the factory, the plant. So there was also a contract. There was also another contract, EPC contract. EPC contract was a contract entered into between Proton with also MMC for the erection of the plant. EPC contract. Yeah. So finally, between all of them, the JV company will get financing at the equity, or I think the financing, I'm not sure. I don't think the financing was done through debt financing.
Probably JV.
I don't know, basically. So I think you call this JVA, not shareholders agreement. Why not shareholders agreement? Why? Because this document specifies all these components. Yeah, all these components. So what is contained in here is not purely voting powers. They mention it contains a lot more activities envisaged from the whole endeavor, whole venture, including this. Among others lah, basically. So I think whenever you are starting a new venture that entails a lot of transactions, concurrent transactions or matters to be undertaken, then the document too is typically known as a joint venture agreement rather than shareholders agreement. Yeah. Now, dalam shareholders agreement ni, what are the CPs? Ada CP tak? Dalam konteks ni, so in a way, this document is the umbrella agreement lah. The JV is the umbrella document. All these documents are subset kan? Documents which are envisaged dalam JV agreement, but the signing of which shall be a CP before the actual commencement of the Proton project is initiated lah. Yeah. The company must raise sufficient capital to finance the purchase of land, to finance the erection of the plant, to pay royalty fee. There was one more document. Technical assistance, okay. Personnel secondment agreement. Key personnel secondment agreement. Some key personnel were seconded to Proton to assist the company in its operation, basically. Yeah. So, okay. Now, what are the CPs? CP is here contain basically the commencement of the JV and the construction of the Proton plant is subject to the signing of the project documents. What are project documents? Various project documents lah. Not only signing of the project documents, the various project documents will also be subject to completion of the relevant project documents, right? Maknanya sale and purchase of the land must be completed, right? If financing, purchase of the land may not be expensive, I suppose, may not be expensive. At that time, 30 years ago, what year was that? 40 years ago, the land value was not expensive. In Shah Alam sama kan. Masa tu lah. So CP, okay, condition which will be fulfilled before shareholders agreement become effective. Now, in a shareholders agreement per se, dalam shareholders agreement per se, shareholders agreement ni is not an agreement entered into on its own. Kalau enter into on its own right from day one, is JV lah. Is JV agreement. Share media synthesis, JV agreement. What are the projects now? Petrochemical project in Sabah. That's what the petrochemical project in Sabah. Who are doing it? The special petrochemical project in Sabah. I mean, I would say the parties sign project document or JV agreement lah. So shareholders agreement typically, a pure shareholders agreement is entered into in consequence of a prior transaction. What is that prior transaction? Purchase of shares. I mean, for example, Nazrina owns shares 100%. She offers me to buy shares in the company, 40%. I buy the shares. Okay. So we have got the prior transactions, sale and purchase of shares. When I complete it, for Nazrina, we need to sign shareholders agreement. Okay. So that shareholders agreement is entered into in consequence of a prior transaction. A full-blown shareholders agreement lah. A shareholders agreement, a pure shareholders agreement, not a shareholders agreement, in the form of JV agreement. Kan? Sometimes you get confused. Ada juga JV agreement come shareholders agreement. Kan? Dalam dokumen ni pun ada voting power ni. Because this document is a mixture of various things to be done plus regulation voting powers of Proton. Dalam dokumen ni there is a mention how many directors would High Court be appointing. Ada. Jadi this document in a way it contains various aspects of shareholders agreement, but it also contains key project documents to be negotiated, to be entered into and negotiated. Yeah. So it is wider compared to a pure shareholders document. Which a pure shareholders agreement yang not amounting to JV agreement ni dia ada pure voting powers only, and typically they are entered into in consequence of a prior transaction in the form of share purchase, share subscription amongst others. Yeah. Contoh. So kalau dalam ni ECP kalau dalam a pure shareholders agreement tadi arising from our transaction tak ada CP. CP dia satu saja. Completion of the purchase tu indicates the commencement of the JV. The moment completion purchase, shareholders agreement comes into effect. Okay, ada soalan tak? Any question? Now, next one. Commencement duration. Now, a company, if you have got a JV culminating in establishment of JV company ni, always remember, JV company ni once established, dia akan wujud lama. It will continue to exist unless dissolved lah. Sometimes it exists beyond the ownership of the promoters. Betul lah? What happened to Proton? Who owns Proton now? Currently, siapa own Proton? Geely and DRB Highcom. DRB Highcom 50.1 cent, 50% more, 50% plus one share. The other one, 50% minus one share. Yeah. So, what happened? Proton tak ada dah. The government, the old Highcom tak ada dah. The old Mitsubishi pun tak ada. The company was listed. What happened? This JV agreement came to an end when Proton was listed. What year was that? 95, 94, 93, thereabout lah. I was involved in that listing lah. And then, eventually, I think maybe MMC was not happy with the way, with the way the Malaysian government nominees of the Malaysian side lah, finally they decided to sell all the shares. Yeah. But the company, although MMC is no more a strategic partner of the company, still there. Proton has got now a new partner lah, Geely lah, basically. Anyway. So, commencement of shareholders agreement normally linked to the date when the parties complete their prior transaction, subscription or acquisition of shares, the parties intended shareholding structure becomes effective. Duration will last until the company is dissolved. Or if the company goes for listing, you cannot have shareholders agreement for a listed company. You can have block voting document, contoh, but the moment block voting document exceeds 33%, you have to undertake mandatory general offer. Say, for example, I own 20% of the shares in listed company, you own 15%. Kan? I own 50%, I'm not in control. But I'm worried about losing control. Kan? I'm losing about being voted out. So I need to get you to sort of, enter into a collaborative arrangement between us. So we call it, we sign block voting agreement or collaboration agreement between us. Contoh. That collaboration agreement may trigger us, both of us as parties acting in concert. When parties acting in concert, when one and another party are deemed to be acting in concert, if our shareholding is more than 33%, we are deemed to have taken control of the listed company. So you better be careful. But that's why you cannot have. So I suppose if I own 20%, she owns 12%, we can have a block voting document because our combined shareholding is still below 33%. Yeah. So sometimes the reality of listed company, people buy shares. I own 20%. I ask her to buy 5%. I ask her to buy another 5%. I ask him to buy 5%. Collectively, we are parties acting concert. Tapi jangan cakap kat SC. Jangan cerita kat orang. Ya. So when you do a corporate transaction, you have to sign the declaration that you own shares. You and no parties acting concert with you own more than 33% shares. I think the disclosure, sometimes you have got an arrangement with someone, we place out shares to friendly parties. So sometimes I think you may be breaking the law, basically, Okay. Capital structure. Capital structure ni for shareholders agreement. Shareholders agreement must have clear provision on capital structure. Authorized share capital, issue share capital, classes of shares. Can you have ordinary shares class A, ordinary shares class B tak? Dia mudah saja, ordinary shares. Any other share capital, any other category of shares, in whatever ways, you call it, basically preference shares lah. Sometimes you don't want to call preference shares. You want to call it ordinary share class B. Ada. Ordinary shares class B. Yeah. Yeah. Then you define. It's possible to do it. Yeah. Ordinary shares class B, ordinary shares class C. Maknanya, dividend must be paid to ordinary shares first. Surplus dividend will go to ordinary shares class B. But if you specify ordinary shares class B to be paid first compared to ordinary shares, then ordinary shares class B become preference shares lah. Contoh. Yeah. So if you want to specify ordinary share will be paid first. Then ordinary share class B will be paid later. Ordinary shares class C will be paid later. I think you can specify. Now, you pernah dengar konsep RCPS providing a coupon rate. Pernah dengar? RCPS providing a coupon rate of 5%. Betul tak konsep tu? The company term sheet is drafted by the commercial guy, send it to you as lawyer. Please prepare for us. RCPS instrument providing for a coupon rate of 4%. Providing for a coupon rate of 4%. That's correct. Tak betul. RCPS cannot have coupon rate. Coupon ni interest. Coupon ni in bond structure is interest. RCPS cannot have interest. RCPS ni dividend. But now there is one flaw. Whenever you are issuing RCPS, even if you specify cumulative dividend of 4%, there is one minefield awaiting you. What is that? The solvency test. The solvency test. Now, if the company is not profitable, even if the RCPS specifies a cumulative dividend rate of 4%, the company cannot pay. The company cannot pay dividend if the consequence of the payment of dividend to RCPS would result in the company not be able to meet the solvency test. Yeah. Siapa COSEC sini? Anyone who work as COSEC? Listed company ke?
Used to be, now.
Apa nama company tu?
Surya Capital.
Oh, Surya Capital. Besar Surya Capital. So sekarang, kalau ada, every time the company wants to pay dividend, there is solvency test, right? Yeah. Solvency test ni directors must approve. Kalau screening directors approve payment of dividend, within the next 12 months, the company is not able to pay the debt. When the debt falls due, then the director is deemed to have committed breach lah. Jadi, payment of RCPS ni, even issued by listed company, is subject to solvency test. To be honest, as we still issue RCPS, kan, even when SPCT is not doing so well, they continue to pay RCPS. They continue to pay, dividend on RCPS. Yeah, there was one instance, there was no dividend paid on the ordinary shares by SPCT. There was one occasion during COVID time. The first time ever in the history of SPCT, they did not pay dividend. Yeah. Typically, I would ask for dividend to be paid. I would fight for dividend to be paid. But I have to look into the statement of the company, and solvency test will be to be done. So I think what I'm saying is that RCPS providing for cumulative dividend, there is still a flaw, there is still a loophole for you to be paid dividend if the company is not solvent. If the company is not meeting the solvency test lah. So normally when you do RCPS transaction, this is not about shareholders agreement per se, whenever you have got an investment structure involved in RCPS, you need to get a guarantee from the promoter lah. The company cannot pay RCPS dividend. The company cannot redeem. The company cannot afford to pay dividend. What do? You get the promoter of the company to guarantee you the payment. Only then you can cover that loophole lah, basically. Otherwise, there is exposure to you, basically. Any form of financing beyond ordinary shares and preference shares such as shareholders loan. Shareholders loan from corporate finance point of view is considered as equity. Shareholders loan is considered as equity. Loan by equity. Contoh ya, Tan Sri Vincent Tan, when Tan Sri Vincent Tan was constructing belakang
Berjaya Times Square.
Berjaya Times Square, ya. Berjaya Times Square. That was undertaken during not long after the 1997-98 crisis lah. Yeah. It was a project that would require a lot of capital. I think it was financed by M-Bank. M-Bank imposed a condition that I will finance only 50% of the project. You must put in equity 50%, I will give loan 50%. The equity ratio was 50-50 lah, basically. So I think the Berjaya Group or Tan Sri Vincent Tan had to sell the stake in DG in order to raise capital. So in other words, ordinary shares, shareholders loan tu is part of equity lah, basically. Sometimes when you do project finance not all monies are injected by ordinary shares, because sometimes you want to have the facility, basically, of getting back the money lah. So maybe ordinary shares, now preference shares as equity, or sometimes order shareholders loan. Shareholders loan ni pun sometimes, when shareholders loan ni, from the stamp duty perspective, shareholders loan ni attract stamp duty also. Sometimes you give shareholders loan 300 million, 200 million shareholders loan, strictly speaking, attract stamp duty, And you draft a document with no intention of paying stamp duty, what? You're committing a criminal offence, under the Stamp Act. So you need to be mindful of how to draft this document. And you want to save the stamp duty. Because this is basically between holding company and subsidiary, or between holding company and investee company. Why you need to pay stamp duty, for example, amongst others. But I think you need to craft it in a manner where you are not flouting the law. So I think preference shares as equity or debt. Distributing factor RSPS, carry fixed dividend, no connect right. So there was one instance we were addressing a client. The client ni, the business manager of the client ni, they were fond of saying RCPS carry coupon rate of 4%. So in all the documents, RCPS shall carry coupon rate of 4%. Tak betul. It was wrong. Coupon rate ni interest rate. RCPS doesn't carry interest rates. It should be dividend of 4%. But I think the lawyer who was advising the client in that transaction was not senior enough. He was just bulldozed. He had no argument to say to the contrary to the business manager or to the business people of the company. So a lot of documents that they have issued contain a statement, RCPS shall carry a coupon rate of 4%, which was wrong lah, basically. Okay, what else? Carrying fixed dividend, provide for mandatory redemption of issuer. Now, redemption, as I mentioned yesterday, redemption has got limitation. It can be redeemed out of profit, can be redeemed out of fresh injection of cash, arising from share issue. So not as simple. You invest in RCPS, I mean, you can get repayment, for example. Now, management and management structure deal with the process of how the JV company will be managed. I mean, how would the JV company be managed? I think we go through some of these documents. Managing director, CEO, CO. Okay, what are the differences between managing director and CEO in Malaysian context? Some companies, they use terminology CEO, president and group CEO. Some companies, they use the title managing director. What are the differences between the two? Sama? Director? Sorry?
Executive director.
Siapa dia?
Managing.
CEO bukan? Yeah, CEO. So what are the differences? What are the differences? Managing director, we inherited our Companies Act, our company law structure is derived from UK. The old standard constitution dalam Companies Act, Schedule A, was it Schedule A? What schedule was that? The constitution. Schedule D ke? Yang the old Companies Act, Schedule 4. Table A. Table A. Saya sebut A tadi kan? Table A. Table A tu disebut one of the directors shall be appointed as managing director, right? Yeah. So that was the structure that so one of the directors on full-time basis will assume the position as managing director. Kan, one of them lah, I know. Yeah. So a managing director is a director on the board of our company. He is an executive director. The title tu can be executive vice chairman, as managing director, sometimes executive director, contoh lah. CEO ni is not found in table A. Table A tak ada CEO. CEO ni as a concept originates from US. CEO in US is similar to managing director here. But as the influence of the US business ni, dulu kalau ada, many years back, if you are a GM of a company, you are the number one lah kan. LLN dulu, Lembaga Literate Negara, there was no CEO. Datuk Ibak, Datuk Ibak, the father of Noriza Ibak, Datuk Ibak. What was his title? Very powerful. He was number one. Title dia general manager ya. General manager, right? General manager. Sekarang if you carry business card general manager, apa ni? What position ni? Which division you are heading? Contoh kan. Betul tak? So general manager now tak ada dah sekarang assistant executive, assistant vice president dah benda tu. Deputy manager tu kan. Data senior officer je. Executive, assistant vice president 3 je. Contoh. Tapi title tu vice president. Assistant vice president 3. Maybe senior manager kot. Or senior executive. Contoh. So these are the impact of US influence. Kan? We are so impacted by US influence, US business, terminologies, Sampai tadi semalam ROFO kan? Right of first offer kan? Dulu English law concept, first right of refusal kan? First right of refusal. Sekarang tak guna dah ROFO. What the hell is ROFO? What I understood, right of first refusal. Sekarang ROFO. Anyway, so I think sama je. CEO in the US context is similar to MD. But you can't find the word CEO dalam standard document. But most of Malaysian companies nowadays, tenaga guna apa title? President ke? Tenaga? President CEO. Tak nak guna dah managing director kan? Tak glamour. Tak glamour. But there are instances in which a company is run by CEO, he's not a member of the board. What does it mean? Nama glamour, title glamour, CEO, but not a member of the board. Contoh, Kesas Highway. Kesas Highway now sold to that entity lah. But Kesas Highway was a JV company, started as a JV company by 4 shareholders. Arab Nation Bank, Arab Nation Development Berhad, PNB, PKNS, Gamuda. Eventually, all the shareholders sold out, left with Gamuda and PKNS. Eventually they sold it to there's one fund company, there was a special purpose vehicle company, purchased all these things, raised bond. What's the name of that company? That purchased the highway. Anyway, so I think it was sold, you know. The person managing that, the CEO of Kesas Highway, before it was sold to this, apa nama entity ni, was using the title CEO. But he's not a member of the board. Not a member of the board. Anyone from Felda here tak? Felda? Felda tak ada. Group tak ada sebut. Kenapa senyum? Group CEO Felda is not member of the board. CEO Felda is not member of the board, not director of the board. Damansara Realty Berhad, CEO is also not a member of the board. I find it, to be honest, I find it strange lah. And I find it strange. You know, but if you to do a study of listed companies, you don't find many listed companies for which the CEO is not a member of the board. It's a rarity to find. But Felda, for some reason, changed the constitution to say that the CEO is not a member of the board.
They have ESCO.
Bukan ESCO. The highest ranking officer in the company is not a member of the board. He carries the title CEO, but not a member of the board. Because in the past, there were some issues lah. And they thought that if CEO has got so much power, you may be exceeding your power, and perhaps because of that, they changed the constitution, which is strange lah. So I think, there are companies for which you have got managing director, you have got executive director. Contoh ada. Contoh dia KLK. There is a managing director, there is executive director. Maknanya there are two executive directors on the board lah, basically. Okay, what else? So there's a managing director. Okay, managing director. So now you may be given an option. Siapa nama Huzaifah. We are starting a new subsidiary. You are given the option of choosing the title, whether you want to use the title CEO or managing director. Nak guna title apa?
Subsidiary CEO.
CEO. But you're not a member of the board. You. Kalau guna managing director, definitely you are director of the company. Many years back, I was advising one guy in ICOM lah. He has passed on. Nama dia Mr. Jayanathan. Very friendly guy. I was travelling to Alustar once with him. To attend to a matter in Alustar lah, to negotiate with SCDC Kedah. He was travelling in business class. I was a junior lawyer travelling in economic class. He moved to economic class to sit next to me. Anyway, so he was saying, Azmi, I would like to ask your considered legal opinion. Tan Sri Jaimajan has decided to post me to head JV company, Highcom Petropipe. Highcom Petropipe in Kulim, in Sungai Petani lah. Kulim High Tech, Sungai Petani. I need to ask you what title I should be assuming. He asked me, whether I should use the title CEO or managing director. I explained to him. Oh, then in that instance, I will follow your advice. I will use the title managing director. I want to have the standing of being a director of the company, because otherwise, if I'm not a member of the board, I don't carry that much authority. Anyway, okay, what's next?
The name of the company that took over the highway is called Amanat Lebuh Rakyat.
Amanat Lebuh Rakyat, basically. They bought, light track, they bought Kesas, basically. Amanah, that's correct. Amanah Lebuh Rakyat, basically. Yeah. Quite a number of companies, two insurance companies. Okay, let's go. We're done with this one. Number 3 is what? Director number 3. The shareholders agreement shall define the power of the managing director to remove any discretionary or inherent authority. At times, shareholders may want the power to be somewhat reserved to the shareholders. Okay, what does it mean here? We want sometime, quite weird. Now, the company, the JV company, is just the vehicle for the project execution. A lot of things will be done by the shareholders. The shareholders will think what needs to be done, how much investment, this and that. Everything is done by the shareholders level. The board needs simply execute the decision of the shareholders. There will be a big decision by the shareholders outside the system of the company. Ada. I mean, sometimes Japanese companies that way, the directors are not really, the directors, major decisions are not made by directors, the shareholders make that decision. Kan? Okay, sometimes between the shareholders, they discuss among themselves, they agree to allocate. Contoh, Daihatsu is a JV between many companies. I think PNB, Mekamara, MBM, Resources Berhad, UNW, PNB, Daihatsu Group, MBM, at least three or four parties lah. UNW and PNB own shares roughly, I think 42% ke, or 38%. Yeah, basically. You know. But PNB is more interested in return. Yeah. The technical side of the business, you leave it to Daihatsu. Maknanya, between the parties, they sort of agree among themselves. The technical side, leave it to Japanese. Because the Japanese, I mean, they were the owners of the technology, basically. You know. Don't meddle into this subject. As long as, so you can focus on the production side, manufacturing side, quality side, give the powers more to the Japanese. On the distribution side, you can do the arrangement lah. Toyota, Daihatsu, they will take more. Then you do the transfer pricing lah. You allocate how much money to be made by the distribution company. When the car is produced, sold, transferred to the distribution company, you make arrangement. So in other words, I mean, that's how they allocate the function lah. PNB typically is a fund company. They're not involved in operational. They're not involved in operations. When, I mean, amongst others, they invest in companies lah. Yeah. So, okay, you may have a 50-50 JV. What is it? Okay, the MD may be designated, maybe a nominee from one shareholder. Kan? Because why? It involves technical aspect of the business. The CFO may come from your side. Kan? Managing director must always be subject to the powers of the board. His limits of authority should be clearly drafted. His term of service should be governed by contract of service and be in place. Where the managing director is a nominee over the shareholder, provision as regard to conflict must be addressed. Contoh, Bintulu. Bintulu Port Authorities. Bintulu Holding Berhad. Bintulu Holding Berhad. Bukan Bintulu LNG. Malaysia LNG, Malaysian Liquefied Natural Gas. Sinar Berhad. There is a JV company. Who are the shareholders? Shell, Petronas, Shell, State Government of Sarawak, or Government of Sarawak, plus Mitsubishi. Who is the nominee? Who has been running the company? I think Petronas nominee. You know, normally someone from Petronas will be seconded. When a Petronas nominee is seconded to the JV company, he assumed the title of managing director, for example. He owes the duty of care to whom? To the company first, right? Betul tak? He owes the company of care to the company first. Kan? But can we be sure that anything major taking place in Malaysia LNG, can we be sure that he share the same information to all the shareholders at the same time? Tak? You faham tak? The answer is almost no, kan? He be discussing with Petronas first. The same thing. Now, Tenaga is a listed company. The CEO is an employee of Tenaga lah. But if the CEO is a shareholder, if the CEO is a nominee of Khazanah, for example, contoh, I mean, sometimes the rules relating to bursa listing pun sometimes not that clear tau. Kan? I think there are in some documents, you are say you are nominee of, katalah you are nominee of Petronas lah. You are nominee of Petronas for argument's sake. Suddenly Petronas nominate you to handle Petronas Gas. Yeah. The strategy of Petronas Gas should be discussed in the board of Petronas Gas. But suddenly you want refinement or validation of that strategy. Can you discuss with Petronas people? Boleh tak you discuss? Sebenarnya tak berapa boleh. Not that permissible. But it happens. You discuss. Contoh. Can the CEO of Boston Holding discuss the strategic direction of Boston Holding with the CEO of LTAT? Is that legally possible? Not too sure. If you do discuss, don't record it. Don't record it. You don't record it, basically. Yeah. So those are the rules lah. Because technically speaking, the strictest rule related to listed company is that when information is flowed, must be flowed to all the shareholders. There must not be any one shareholder who gets special information. Contoh. Yeah, basically. Yeah. Why is it that you must share with the ordinary shareholder? I'm a shareholder of the company. Contoh. If the company suffers a problem, big problem, for example, why is it that you must share with that shareholder first? Why don't you make announcement? Contoh. So I think if you happen to be on the board of listed company, any discussion about some issues involving shareholders, discuss about meeting, remove them from the minutes. Don't capture them in the minutes. So I think here we are talking about conflict lah. If you are minority shareholder, you must say, the duty of care of the managing director shall be first and foremost to the shareholders. If the managing director encounters any issue affecting the interest of the company, generally the flow of information about that problem must be made to all the shareholders concurrently. No shareholder must have the benefit of getting to know a particular issue earlier than the other shareholders. You can put that clause in the document, right? So that you have got access to information concurrently, basically. Yeah. Okay. Principally, the law relating fiduciary duties require him to discharge good faith obligation to the company and not to the shareholders whom he is part of. Yeah. Allocation of management function between among parties. I've touched on this. Align your position that you are requesting for with your company's business objective. What is it that you are interested? Are you interested more in the return? Are you interested more in getting to understand the operational process or what? Are you technical? Are you interested in the operational process? Are you investing to understand the business or you are investing for the return? Contoh. Macam apa? Worldwide. Worldwide has got a JV with in one major project, IBB project with Capco, right? Capco is currently listed company. Capco is a 50 billion market cap lah. Yeah. So the investment is what? What is the main process? What is the main driving force of the investment? Yeah. Return. Return. But at the same time, you also want to understand the business process, so then you align your position with your objective. Contoh. Where a shareholder ceases to be a shareholder, his accrued right and liabilities would not be affected. You may cease to be a shareholder, tetapi your accrued rights, whatever rights that you have acquired during the tenure when you were still a shareholder, will remain the same. You can still initiate an action post. Inclusion of new shareholder, where a new party comes in to replace an ongoing shareholder, an instrument to finalize the exclusion of the outgoing shareholder, and then the entry of new shareholder is normally referred to as deed of adherence. Yani, the general rule is that any new party coming into the shareholders arrangement will be bound by the existing terms.
Is it possible that this new shareholder wants to have a separate?
Boleh, macam Japanese tadi saya sebut tu. Yang the Japanese big group tu that came in, they bought the interest of the share. Boleh, you can negotiate lah. It's a bargaining position depending on the position of your position or depending on the position of the incoming party. Transfer of shares preemptive right. Shareholders agreement applies normally to private companies and will contain provisions for preemptive right. Preemptive right tak ada dalam public company. Tak ada dalam public company. Preemptive rights. Registration on transfer of shares pun tak ada dalam public company. Registration of shares, registration on the transfer of shares does not exist in the constitution of any public company. Preemptive rights, shareholders agreement will provide for a more detailed mechanism, especially on the pricing compared to the provision of the other negotiations. Transfer of shares must be aligned to your company's corporate objective. What does it mean here? Say, for example,